This is WAAY 31 Law Call.
Good evening and welcome to WAAY 31 Law Call. I'm Robert Lane, sitting in for Sharon Doviet. Tonight we're going to talk about wills and trusts and things like that, and all about legal problems getting older. I wonder if that's why they asked me to sit in. I'm a little worried now. So will you be able to retire and relax during your golden years, or will you need to keep working? We're going to find out, do you have a will, and do you need a trust, and all that type of good stuff. Give us a call at 256-536-0077, 256-536-0077. We'll answer your questions live on the air. With me is William Meservey of Timberlake, League and Brooks, one of my favorite lawyers. And what they don't know is that he speaks Spanish. So if English is not your native language, this is the attorney for you.
Yeah, and regardless of what your native language is, if you're in this country, are going to encounter legal problems. And so, it's important that there are lawyers who can address those, and we're always happy to.
And Will, we're going to get to you in just a minute, but we're going to do a You Make the Law Call, which is a little more on your personal injury side of the business. Now you watch this. I'm going to say you're representing the guy in the sedan, and boom, he hits. So, as you've told me, if you're 100% at fault in Alabama, it's not good for you.
Yeah, so there are contributory negligent states, and then there is the more modern approach, which we call comparative negligence. And so in a contributory negligent state such as Alabama, if you contribute to the cause of the collision, no matter how slight, you're barred from recovery. Now, I'm not sure where exactly this video was taken. It almost...
it's foreign.
It seems like it is overseas as they're driving on the wrong side of the road on America. But, when you see him pull out, he's trying to shoot the gap. And so, irrespective of where the video is taken from, this is a problem we encounter routinely. Traffic backs up, and you get someone in a hurry, and they want to try to shoot that gap. And what happens when you shoot the gap is you can't really fully appreciate what the hazards are. And so it's not uncommon in that type of situation where the other side only has to prove you're 1, 2, 3% at fault for shooting that gap and not looking out, and that's all it takes.
Well, we're talking mostly wills in the states tonight. You want to introduce our guest?
This is Will Pilot of Pilot Estate Law.
That's it.
And Will is a fantastic estate lawyer. We're tickled to death to have him on the show tonight, and he's going to help us through this, navigate this topic, which is not an easy topic to navigate.
Okay, so do you have a will?
I do.
Oh, I was so hoping you would say no.
I know.
Well, the question is, do you have a will?
I do. And I'll tell you, it was my 3-month-old that made us update our wills. And so there's kind of 3 main times in people's lives that I tend to see them for wills. It's right after they have a kid, or they've got 1 or 2 little ones at the house. And then I tend to see folks when they bust that old will back out when their kids are 25 or 30 years old, and we want to update it. And then normally one last time too, late in life. So
Now, if I die without a will, what happens?
Yeah, that's a great question. So you're said to have died intestate. So there's you can pass away testate or intestate. Testate means you have a will, and then intestate means you don't have a will. And so in that case, your estate will pass according to the Alabama statute of intestacy, which is to say to your heirs at law. So that would be to your spouse and then your kids. And if there are none, we would go back up to find other heirs.
Yeah, and so, what happens is if you die without a will, just like Will said, intestate, rules of intestate succession, some of these big legal terms we throw around, all we're really saying is, look, the law is going to set out how your assets, your possessions are distributed when you pass away if you die without a will. There's certain statutes that are going to say, look, this is where this goes, this is where it doesn't go.
Exactly. And William, a lot of people would want to say that I want to leave more to one of my children over the other, or everything to my spouse first. If you die without a will, your estate will pass partly to your spouse and partly to your kids. But as you said, some of the statutes, and I think the wrongful death statute, you have to follow the statute of intestacy, right, for those damages, which is a peculiarity of Alabama law. But
yeah. And so Well, when we talk about estate law, what all does estate law encompass? Are we talking powers of attorney? We hear these terms, living wills. What are these different types of areas of estate law?
It's a great question. And William, it's so much better to get your planning done on the front end. And so when you're able to come in and meet with a local lawyer to get the kind of the four key main documents that we would recommend will be a last will and testament. That's how you want to leave your property. You name an executor and an alternate. Power of attorney, which is an authorization for someone to act for you. Healthcare power of attorney, which is very similar to regular power of attorney, but for, you guessed it, healthcare decisions. Lastly, the advance directive for healthcare, primarily for end-of-life decisions.
Okay, and so let's talk about that one. End-of-life decisions. What are we talking about?
Yeah, great question. And I'll say too, we try and use the term advance directive. The other term that you might hear, William, is living will. Mm-hmm. Advance directive, living will, those are the same thing.
Okay.
But that is the instrument, and it comes primarily from the state code, and you'll go through and mark what you want to have happen if you are on life support or if you have artificial food and hydration. And so if you are terminally ill or permanently unconscious, you have to go through and make decisions about whether you want those things or not.
Right. And so what happens if you don't have that advance directive or living will, as it's sometimes called?
Well, William, I do a lot of state litigation too, and unfortunately we see where families want to, where there's conflict over that. And so if you don't have that set out, you may have one sibling that, or one child that says, let's keep mom or dad on life support, and one says take them off. And so those are difficult decisions for those families to make that leads to conflict. So much better just to have that planning done and make it clear to your family what your wishes are.
That's great.
Well, let's take some phone calls, shall we?
Let's
well,
do
I know
it.
we have Jeffrey from Florence standing by. Thank you for waiting for us. Jeffrey, what's on your mind?
Yes, I was calling. My mother passed away 3 weeks ago, and my brother is special. He draws a disability check, and she was the only one that was on the payee on his checks. And because he's not able to sign a check and, write a check. And in the will, I'm supposed to take care of him and take care of all her stuff. I'm her executor. I was her power of attorney and all that.
Yeah, Jeffrey, I think you've got a couple points there. So the first is having a rep payee to administer to hold his check. You're going to need to go and get a new rep payee appointed for him. The other part is I'm hoping, fingers crossed, and Jeffrey, first let me say too, I'm sorry for your loss. That kind of gets lost in some of the in some of this, but want to certainly say and certainly feel for that loss, but. The second part of this is I'm hoping that the will adequately addresses and includes what we call a special needs trust. And so if he's receiving public benefits, then we want to make sure that there's provisions within that will or trust to make sure that we don't disturb those benefits. And we accomplish that through something called a supplemental needs trust, so that we don't disqualify him for his benefits.
And so in this instance, is it a situation where he would just need to contact Social Security's office and set an appointment and go in and they could help him make that change for the payee?
Yes, yeah. For the rep payee, yes, that's what you would do. And then for the second part of that question, to make sure that any inheritance isn't going to disqualify him from benefits, you would really want to get with an experienced estate planning attorney to make sure that either the special needs trust provisions are included in that will, or you may have to do what's called a first or third party special needs trust where you set it up to make sure that we preserve his benefits.
Well, let's go to Jeff here in Madison County and see what's on his mind. Hey, Jeff, thanks for calling in.
Thank you. Yes, tell you a horror story. Had a grandmother that passed away in 1969 without a will. All of her children passed away. I am a grandson. And we ran into a roadblock because she did not have a will. And so we have gone through all the procedures of getting all the family members, their children, a lot of the grandchildren have passed, And now they're saying that we need death certificates for everyone. Is that true?
Yeah.
But it's a nightmare.
Yeah.
I wish everyone listening to this program, I don't care how old you are, if you have real property or money, get a will made.
Well, thank
Yeah.
you, Jeff. That was great.
And I could tell you a similar horror story. I received a call from a client once upon a time, and he told me, he had been taking care of his grandmother's house for the past 20 years. She'd been deceased. And when she had passed away, his parents never opened an estate, never got that deed transferred over. And it was a very similar situation. He'd been paying taxes on this house. He had been maintaining the house. But there was no way for him to then sell the house without going through those same steps. So those problems can compound generationally.
That's right, William. And what Jeff has on his hands is called heirship property. And that happens in Alabama. It tends to happen in the South, frankly, where people tend not to probate, mom or dad's, and it becomes grandma or grandpa's estate. And now all of a sudden we've got, 30 heirs. It's not uncommon for us to have 30 heirs from what we call these heirship property cases. And now in this area with the value of land increasing, all it takes is one heir to force the sale through a process called sale for division, and the whole property could be sold to where heirs get their part of their piece of the pie, more or less.
And we've seen that before as well, where granddad's going to leave the family farm to 12 grandkids, and one grandkid says, "Hey, I want out."
Yeah, that's all it takes.
And he can force the sale of the entirety.
That's all it takes. So it's so important too, William, when someone does pass, to get that estate probated, to get that title changed over. A will can only be probated in Alabama within 5 years. So even if grandma or grandpa said it should go to one child or it should go in a certain way, if you don't probate that thing within 5 years, that's out, and you have to follow the statute of intestacy. And so, it sounds like our caller just got this heirship property, and that could end up either it's going to be a lot of title work, or it's going to end up as an heirship property sale for division.
Well, who's going to get your stuff? That's what we're talking about tonight. Give us a call. We'll be back in just a minute.
You're watching WAAY 31 Law Call. Your rights, your calls, live. Presented by the Tennessee Valley's award-winning personal injury and wrongful death law firm, Timberlake, League & Brooks. Featuring the knowledge and experience of Attorney Michael Timberlake, Attorney Will League, Attorney Heath Brooks, Attorney William Maservi. And hosted by broadcaster and family law attorney Sharon Doviet. This is WAAY 31 Law Call.
Hey, welcome back. We're talking about wills and estates and what happens to your stuff once you die. Rick from Athens has been patiently standing by. Hey, Rick, what's on your mind tonight?
Yeah, so essentially my actually it'd be my half-brother, was actually adopted by my dad's mom and dad, my grandparents. And so now we're in our mid-50s now, of course. If my mom passes away and does not have a will, does he have any right to anything at that point?
Yeah, it's a good question. And the Alabama State Code provides that adopted children take just the same as natural-born children. So if he's legally adopted, then he will be included in the statute of intestacy just the same. And of course, that could also depend on, if your grandparent or parent had a will, then of course things could redirect. You can certainly leave your estate to anyone in Alabama that you choose, with the exception of you cannot cut out your spouse. That's kind of the one. You cannot omit your spouse. They're entitled to what's called an elective share. But in this case, I think it'll just depend.
An elective share is how much?
It's there's two formulas, but typically it's 1/3 of the estate. So.
Now, adoptive child could also inherit from their biological parents.
Yeah, that's right. That's right. So they could end up inheriting either way. And so the adopted, it's a little bit cleaner. Where we see more of the issue is with the stepchild and stepchildren relationships. And so stepchildren do not take. They have to be either legally adopted by their step parent in order for them to take. That comes up.
And if they are legally adopted by the step parent, then they can't inherit from the biological.
They could. That's kind of a question of fact, but typically they would still be able to inherit so long as like there's a case like where the father doesn't hold himself out as the father. Then in that case it could cut off.
Interesting.
So in your business, though, if someone gets hurt and dies in a traffic accident, that's what, wrongful death, right?
That converts it from your standard negligence claim into a wrongful death claim. That's correct. And so when you die, you have really no right to bring a claim in the state of Alabama. And so what happens is you would need to then open an estate. The estate would be the proper party that could bring an action on the behalf of a deceased person. And that would be done by and through the personal representative of the estate. And how do we find out who the personal representative is?
Exactly. Well, typically, if you've got a will, then there should be an executor named inside the will. If there's no executor named because there's no will, then you have to go line up a bond, and then you would file that with the probate court, and the court would have to appoint you as the personal representative of the estate. So bonded for the value of the estate, and then filed and appointed by the court. Then one quirk on that too is you, in order to be we call it an administrator if you don't have a will. In order to be an administrator in Alabama, you have to be an Alabama resident. So you cannot have a Tennessee resident serve as an administrator of an Alabama state. They can serve as executor. If there's a will, that's okay. But if there's no will, you must be an Alabama resident.
Yeah, and so we've run into this before where you have an individual who passes away, whether it be in a motor vehicle collision or some other way, and their family lives out of state. And so there are actually county administrators that you can then use in that situation. But it doesn't have to be a county administrator. It could be, someone agreed upon.
That's right. That's right. Yeah. So we'll often look, William, to see if there's any other family member that can do it, and if not, then they can get a local attorney appointed. There's a couple counties. Jefferson County's one where you have to get the county administrator appointed first, or have that person release the claim. But typically, we look for someone. It needs to be someone that they can trust. But if we can find someone to trust, that certainly will bring it home. Otherwise, you could end up with a race at the courthouse to see who will get appointed and end up with the case.
Yeah.
And you were explaining earlier, if I put my son on my bank account so that he can administer, then I die, that money doesn't go to my will?
Robert, we see that come up far too often. It's such a critical point. If you put one of your children on your bank account, or if they're named as TOD or joined on the account, then that child, that property becomes theirs at death. They're going to get that account outright. And so a lot of times we see maybe where mom or dad wants to put one of the kids on the account to help pay bills, but the thinking still that, this money will be split later. And boy, I'm so careful to caution people on that child will legally receive those funds regardless of what your will says.
Well, we have Lisa from 5 standing by. Lisa, what's your question tonight?
Yes, my mother, she has land and a house, and we've got it set up where if she aches and passes away, that it comes to my brother and me. But if she has debt collectors, do they have a thing against her estate after we inherit that?
Well, another good question.
Yeah.
So they have to file claims in probate court if there are any. Lisa, your job will just be to send notice to creditors. And basically, it's just a letter saying, hey, we think you might be a creditor. Then the burden's on them to go file their claim in probate court. If they don't do it, then the claim's forever barred.
But there's a statutory period that an estate must remain open to give creditors an opportunity.
Exactly, William. So that period is 6 months in Alabama. So we have to give actual notice to known creditors, and then the lawyer typically, you have to publish for unknown creditors in the newspaper or the Madison Record. You have to publish in the newspaper of general circulation in the county.
And do these companies check those newspapers? How does that?
Some of them do.
Yeah.
Some of them do. And then we'll see a lot of times where Visa or MasterCard or Amex may file a claim against the estate, but then an enterprising estate lawyer can help negotiate that claim down, or maybe even object if we don't think it's valid and get it barred that way too. So.
Okay, we're going to head over to Athens right now. Tammy's standing by. Tammy, which question?
Hi.
Hey.
My mom, she's 80 years old, and thank goodness she's in good health. But I'm an only child, and she is widowed, and she doesn't think that she needs a will because I'm an only child and I'm automatically going to get everything. She has a house that is paid for. She has a little bit of money in the bank, which I'm on the bank account, but she doesn't think that she needs a will for the house.
Yeah, so I mean, I certainly can sympathize with that, but I'm still going to say that she needs a will. If nothing else, it's going to save you in probate court costs. You won't have to, if there's a will that waives the bond, you won't have to go and pay the bond
fee.
Premium.
Yeah.
So.
And in that vein, one important thing is while she's in good health, one of the documents Will mentioned at the beginning of the show is power of attorney. And power of attorney is sometimes we, in the legal field, called a legal hat, right? And you have to have that legal hat while she's in good health in order to make decisions for when she's no longer in good health. So if she were to get dementia or have an altered mental status, as we call it in the legal field sometimes, in the medical field, once you have that altered mental status, you can't enter into a binding agreement anymore. And so while you can enter into a power of attorney, that's an excellent document to go ahead and execute, which will save you so much time and trouble in having to get guardianship.
That's right.
Which is the what you have to do through the probate court.
Yeah, guardianship, conservatorship. And then one other thought for this particular caller, if something, God forbid, were to happen to the caller too, then there needs to be a plan for what happens to that. If the caller has underage kids, there needs to be a trust provision for that. So there are some nuances there to address as well.
We're going to take a break and be back in just a minute. Stay with us. If you need to contact anyone here on the panel, Will Pilot is Pilot Estate Law in Huntsville, 256-529-4747. William Reserve is, he speaks Spanish. He's an Eagle Scout. I mean, why would you trust this guy? He's at Timberlake, League & Brooks at 256-536-0770.
And although she's not with us tonight, family law attorney Sharon Doviet, everything from divorce, child custody, 256-539-7337, and she is SharonFamilyLaw.com.
And I want to tell you a little bit about the Wheelchair Brigade at Broadway Theater League, which is indeed sponsored, as you can see there, by Timberlake, League & Brooks. They just finished up Jesus Christ Superstar. They're doing Pretty Woman soon. But all you do is you call Broadway Theater League, and because of the good graces of Timberlake, League & Brooks, they will send someone down with a wheelchair and make sure you get to your seat and then pick you up afterwards and take you to your car.
We've done that for a few years now, and everyone seems to enjoy it, so we keep doing it.
Excellent. Well, listen, join them on the midday show tomorrow right here on Channel 31. They'll be taking your legal questions too. Thank you all so much.
Thank you, Robert.
Okay, Sharon, we'll see you next week. Okay, can you take a picture?
Long after guests leave.